welcome to the First District Court of Appeals. We have only one case on the docket to be argued today, and that is State of Ohio versus Jerome Henderson, case number C-220216. Will the attorneys please state your appearance and your readiness to proceed?
Daniel Truitt, on behalf of defendant appellant Jerome Henderson.
Joshua Loya, on behalf of the state appellee. We are ready to proceed.
Great, thank you, Mr. Truitt. Whenever you're ready, would you like to reserve some time for rebuttal?
2 minutes.
2 minutes. You have 15 total. I'll keep your time. When you have 1 minute to go, the yellow button will light up, and then red means you're out of time. So whenever you're ready.
May it please the court, if due process is to have any meaning or significance in the context of eyewitness identification procedures, then this court should reverse Mr. Henderson's conviction because it was based solely upon identification procedures so tainted that even the state concedes they were unduly suggestive. Here we had an officer, Officer West, who was attempting to identify the driver of a vehicle that refused to stop. And in Officer West's own telling, he had only, quote, a few moments, end quote, to observe the driver at night with the vehicle's windows rolled up. And Officer West's inability to obtain any meaningful description is evident by how Officer West described the driver the following day to the crime squad unit, where he described the driver simply as a black male wearing a beanie and a t-shirt. And based solely on this non-description, if you will, the crime squad unit pre-identified the driver as Mr. Henderson and then proceeded to show photos of only Mr. Henderson to Officer West.
How did the crime squad unit pre-identify him? How did they know or think that this was him?
Your Honor, the record is somewhat unclear on that. I think Officer West tried to make the court believe that it was due to two things. One, his presence in that vehicle, and two, Officer West asserted that the photo had been taken earlier in that day. But both of those pieces of evidence were clearly inadmissible hearsay because Officer West affirmed that he had no independent knowledge of when or where the photos were taken. And on page 59 of the transcript, the court acknowledged this issue by expressly stating that it was excluding the evidence pertaining to the vehicle. And so I think the fairest reading of the record is that any evidence relating to, or any statements by Officer West relating to when or where the photo may or may not have been taken should not be considered by this court and should not be considered as to resolving any issues of reliability.
Let me ask you, Mr. Truitt, at least my understanding from the record that the events occurred, the officer asked other officers if they knew who this person was. He described the vehicle and gave a description. And at least my reading of the record was they said, oh, yeah, we know who that is. And they had a picture of your client wearing the exact same clothes that the officer described, purportedly taken, I thought, the same day or the day before. Was that in the record?
Again, Your Honor, Officer West did make that statement that one of the photos had been taken earlier that day. He also stated that it had been taken the day before, but regardless of when the photo had been taken, I think there's not any dispute that that was inadmissible hearsay because Officer West had no personal knowledge, and the court recognized that by its exclusion of the vehicle evidence on page 59 of the record. So
there was an objection and that was excluded?
There was no objection, but the court nonetheless did recognize it. And regardless of whether there was an objection, I think this would be a clear case of plain error. But nonetheless, the trial court did recognize this issue with Officer West having no personal knowledge as to the time or the place of the photos, eliminating those two allegations from the calculus of reliability. That leaves your third point, Your Honor, as to whether the suspect in the photo was wearing the same clothes. And, you know, to the point that Officer West only could say that the driver was wearing a dark-colored beanie and T-shirt. In fact, his description to fellow officers didn't even have the color had no color whatsoever as to the clothing. So it's hard to see much indicia of reliability there, because a description, you know, that can be summed up as a black male wearing a T-shirt and a beanie is so generic, I think, as to be mostly meaningless.
Well, I mean, the standard here is, or correct me if I'm wrong, we look at the totality of the circumstances to determine if the identification was reliable, right?
Correct, Your Honor.
Okay. And do we have enough information? It seems like the record is kind of blank on why this photograph was brought to the officer for identification to begin with, like all of the information about why they believed it was Mr. Henderson and why they brought this one picture to the officer and said, hey, is this him? So, I mean, if we're looking at totality of the circumstances, wouldn't this be better left to a post-conviction type of thing where the record could be more developed? I mean, do we have enough on the record to determine what you're asking us to do?
I believe so, Your Honor, for the primary fact that it's the state's burden to show that the evidence was there to support admitting this evidence. The record, that there was enough in the record to support a motion to suppress. And the fact that none of those indicia were admitted by the state should not shift the burden to the defendant post-conviction to have to further develop the record. The court and the trial counsel should have addressed this issue with the evidence before it. The state failed to bring any supporting witness to develop the very facts that Your Honor is suggesting might have been needed to develop or prove totality of the circumstances, such as were there other indicia of reliability, you know, as to, you know, prior use of the vehicle. There could have been any number of things, but the record only supports speculation via hearsay on those points.
Right, but it's your burden to prove at this stage on this direct appeal that your client would have won a motion to suppress, right?
That is correct, Your Honor.
We have all this stuff that we don't know. So how are you able to show us that a motion to suppress would have been granted?
Your Honor, with the record that we have before us, the very evidence that the state brought to bring this case to a conviction, that evidence itself shows that the identification itself, one, was unduly suggestive. Even the state concedes that point. Two, that the other evidence that could or might have been there to develop a reliability under the totality of the circumstances is merely speculative. But what we do know is that most of the factors of indicia that we would look to are non-existent. For example, factor one, which relates to the witness's opportunity to view the suspect, that's a closed book as far as the record is concerned. We know that Officer West had only a few moments. Factor two, which relates to the attention, the record is clear on that Officer West was attempting to make this identification at night in those few moments while he's running up to the vehicle, while the vehicle is moving. Officer West is having to move around for his own safety.
Counsel, didn't he have about 4 or 5 seconds where he was fairly close to the vehicle and had a pretty close view?
It was approximately 4 seconds, Your Honor. So yes, that is correct, but a lot was happening in those 4 seconds. He was yelling at the driver to stop. The car was moving during that entire time, and it was at night. And so looking at the totality of that evidence, factor two also weighs in favor of suppression. And factor three, which relates to the accuracy of the witness's description, that weighs in favor of suppression because Officer West's description was anything but precise. It was the very definition of generic. And so And finally, the fourth Biggers factor relating to the certainty of the witness weighs in favor of suppression because, as Ohio courts have held, where the certainty is itself the result of unduly suggestive procedures, then the court should disregard that factor. So I'm not sure that the state could have done much, even if they had tried, to develop more indicia of reliability in this circumstances. I think the record is fairly complete that as to the relevant Biggers factors, 4 of the 5 weigh in favor of suppression. And, Your Honors, I would also point out that the 2 additional factors relating to identification of a stranger and that the identification was cross-racial also weigh in favor. And there's nothing that the state could have brought forth to, get rid of those factors. That's in the record, and that part of the record is complete. Sociologists and courts alike have developed a consensus that cross-racial identifications are inherently more unreliable. And here, it's only compounded by the fact that we have a cross-racial identification of a stranger, as Officer West affirmed that he had never before seen, or at least did not recognize, the driver. So in total, we have 6 of the 7 relevant factors that weigh in favor of suppression. And the evidence that would support or not support those factors is complete and in the record. And there's not much that I can imagine that the state could have. It would be only hypothetical or theoretical. I suppose, there could be any scenario that, the state could have come up with something, but I think the court should look at the record as is, and it's fairly complete on these points. Finally, if the court would allow me, I would like to just address one factual assertion in the state's brief as to, they do point, and I know I've touched on this, but I just want to reiterate that the state attempts to build up the indicia of reliability by citing to the facts that Officer West claims that the photo was taken earlier in the same day. And I just want to make it clear to this court that the trial court seemingly recognized this issue with hearsay, and on page 59 of the transcript appeared to disclaim and exclude that evidence. And I think that's important for this court's consideration of this appeal.
So it excluded the evidence that the photo was taken earlier that day?
So the court was unclear as to, if I could back up, Officer West issued one compound statement on page 23 of the transcript where he says that the photo was taken in that vehicle earlier that day. And then there's some other discussion where then Officer West says that actually maybe it was the previous day and there's some, indecision on his part. But then when we go to page 59, the court appears to refer back to that very sentence and say, I'm excluding the evidence pertaining to the vehicle. And so if we look at that sentence and that page in general, I think the fairest reading of the record is that the court was excluding both the vehicle evidence, and although the court did not explicitly state the time frame, because it was brought in together, I think the fairest reading is that it was also excluding that. And in any event, that it would be plain error.
So let me just be clear as to what you're arguing. So you're saying, so on page 59, the court says that he puts part of this decision on the fact that he saw your photograph, meaning the defendant's photograph, the very next day when it's still clear in his memory, meaning the officer's memory, and he confirmed it was you. And then he says it's hearsay that you were operating the same vehicle when they took the vehicle photograph of you. But I did not consider that hearsay. So are you saying that in that last part where he said he did not consider that hearsay, are you saying that that also means that he didn't consider that it was in the same clothing? Am I understanding that correctly?
Not the same clothing, the time frame that it was taken earlier that same day. The reason that this is important is because the state points to the idea that the photo was taken earlier the same day as to decreased the likelihood that the similarity in clothing was coincidental. And this is important because the statement regarding the vehicle, which the court excluded, was given at the same time. It's the same sentence where Officer West says this photo was taken in the vehicle earlier that same day. So if the
But
court,
said it was the very next day, not the same day.
so, Your Honor, I believe that when the court's referring to the next day, the court is referring to the timing of how soon Officer West made a photo
Okay.
identification. So that would be separate, and I apologize for being unclear, that'd be separate from the issue of when the photo itself was taken. So if, for example, the photo had been taken 30 minutes before this incident, that would suggest a much higher likelihood that the similarity in clothing was not coincidental. But of course, that's not the case here, and any statements pertaining to the timeliness or the time frame of that photo is hearsay and speculative. And I'm just pointing out to the court that I think the fairest reading of what the trial court was saying is that sentence, that summary of evidence of when the photo was taken was excluded and should be excluded from this court's consideration on appeal.
Thank you. You will still have 2 minutes for rebuttal.
Thank you.
I won't take that from your time. Thank you. Mr. Loya?
Yes, Your Honor. May it please the court. We're here today because the appellant is asking that the court consider that the counsel for the defendant at the time was ineffective. It was not. The standard as put is whether or not it fell below an objective reasonableness. And their main claim is that his decision not to file a motion to suppress identification fell below objective reasonableness. Based on the law, they would need to prove that he would have succeeded. Now, while there was only a single photograph shown on this matter, in determining whether or not he would have succeeded, it would be considered one of the biggest factors to tell you circumstances.
Well, he doesn't actually have to show that he would succeed. It's just a reasonable probability.
Or even on a reasonable probability, they would not succeed, is what we would argue. Now, that said, the biggest factors do weigh very heavily in favor of the state. The first and second factors, which were what his opportunity was to view the defendant at the time, were not just timing, its situation, what the location was. As stated, he had several seconds to do so to view him. He was within 1 foot of them, running up against the vehicle, looking through an untinted window into the car. He was able to describe him as a black male wearing a beanie, a sweatshirt. He also described him as having a beard and distinguished cheekbones. Furthermore, Your Honors, based on the fact that his attention was fully on this man as he was giving him orders, it was his sole attention was him as the car was driving around, as he was looking directly at him through those windows. Based on that, these two factors fall within the state's favor. Moving on from those two factors, the next factors under Biggers. So, Your Honors. Next factors following under the fact that the defendant going after the photographs that were shown. Is that the accuracy of the witness's prior description of the criminal is, as stated, the photographs that were shown were taken early that day, shown to the officer the next day. Well, it's still fresh in his memory. They, as was shown, they had him wearing the exact same beanie, exact same sweatshirt with the beard. With that, he was able to identify that this was the individual with 100% certainty. And that also goes to the fourth one, is his level of certainty. The level of certainty was at 100%. He was certain this was the individual he saw that night within 1 foot of himself through the window of the car. The window was untinted. And the time elapsed was only the next day. The courts have held that in the past that is suitable time, that is within the reasonable time that he could have had that within his memory. And frankly, it would be very difficult for him to forget that moment as he had watched the car strike another vehicle in front of his cruiser, ran out to it, and was holding onto the vehicle as it kind of drove away from him. Now, the appellant attempts to add additional factors to this. However, that simply cannot be considered. We're here for ineffective assistance of counsel, not a motion to suppress. And ineffective counsel is based on what the defense counsel's reasonable assumption on the law at the time. Additional factors are not considered part of Biggers and are not the law here in Ohio, the First District. So he only has those bigger factors to go on. And based on that, it is reasonable he realized he would not have succeeded. He would reasonably not succeed at a motion to suppress and did not file it.
Where are the additional factors from?
I believe the additional factors are a federal court, and I believe they are in civil cases as well. But
What are the additional factors?
Your Honor, I did not actually include those as well because, as I stated before, we were not going to address them because they are not to be considered. They usually are not considered by this court. They are not under the First District's they are not under the First District's current requirements for motion to suppress.
So in our determination of whether it was ineffective assistance of counsel, you're saying that we only look at the factors that are in this one particular Supreme Court case and no other factors. You're saying these other factors are never used to determine whether or not eyewitness identification is reliable?
Your Honor, I believe they would not be used in this case. As stated, we're not here to determine if the First District should change its motion to suppress. We're here to determine whether or not the defense attorney at the time, with his understanding of the First District case law and the law as it stands, would have made the decision. The First District case law, as my understanding is, only includes the Biggers factors, nothing else. So any additional factors, outside factors, would not be in consideration for him when making this strategic decision to file a motion to suppress or not.
So something like cross-racial identification, for example, I think that was one of the additional factors. That's not to be considered.
Your Honor, I believe that is not considered in a motion to suppress at this time. If we were here for a motion to suppress, that would be something to be argued, but we are not. We're here for ineffective assistance of counsel.
Let me suggest to you that Judge Mallory considered that factor when making his decision. Again, it's on page 59, and he said, I'm very careful, I'm very aware, and based on that, that's why I'm making the decision I'm making. Do you understand what I'm saying? He
Yes,
considered it, apparently.
Yes, Your Honor. I do believe he may have considered, Judge Mallory considered, I know he is very aware of these situations. Yeah. He is very considerate of the whole factor, as well as the fact that he considered certain things hearsay that were not objected to at the time. So he did not include those in his decision-making and still found the defendant guilty and still found identification, even without those additional evidence. However, I will note, to go on to some of the factors, some of these that were brought up by the defendant, that the photograph that was shown would be left out. He did mention that the photograph itself was shown within an amount of time, and so that would add to the credibility of the officer at the time, on that same page. Your Honor, I believe the only photo he said he would not consider at the time immediately was the vehicle itself, but he did consider that this photo was shown to him, and it did show that it was able to identify, based on this photo, he was able to identify that this was the individual within the day. Your Honor, I know that they then move on to state that there was not sufficient evidence laid out to make a fact finding on this. As stated, this all presupposes that the identification was faulty, that the identification was suppressed.
The whole case relies on this identification.
It does.
Without it, everything falls, right?
It does, but as stated, no motion to suppress was filed. It was reasonable not to file a motion to suppress based on the law as it is now, and as they were stating, as the attorney's action there, because it's more than reasonable that he would not have been successful at this motion to suppress. And based on that, the identification stands and should stand. And with that, in addition with all the other evidence of the officers witnessing the accident, being that close within a foot of the defendant through an untinted window into the vehicle, being able to identify him as a black male in a sweatshirt, with a beard, distinguished cheekbones, and being able to see the picture that was taken the day before of the defendant and saying, that's the guy, this was who it was, the identification would have stood and should still stand.
How many seconds did he say he was next to the guy and looked within a foot of the window?
Yeah, I believe he said he was there at least 4 seconds.
Okay.
So, but he did have ample opportunity to stare into that window and look at somebody.
Right. And the record was specifically clear that the window was untinted. You've repeated that several times.
I believe the record was specifically that he said the window at the time was not tinted. That's really, we ask you to uphold the lower court's finding you guilty based on that, Your Honor.
Thank you so much. Mr. Truitt, you have 2 minutes for rebuttal.
Your Honors, I think it's important in this case that the court keep an eye towards the big picture. The General Assembly has spoken on how photo identifications and lineups should take place. There's a lot of case law that has developed on the importance of objective identification procedures. And here we have an identification where police pre-identified the suspect and then proceeded to show only photos of that suspect. And it's important to not lose sight of that larger picture in light of what the General Assembly has had to say and what courts have had to say and what precedent may go forth from this case on how police can utilize identification procedures moving forward. Secondly, I would just note that the reference to high cheekbones and a beard is not a part of Officer West's pre-court identification. It's only a part of Officer West's in-court identification. And that distinction is important because we are primarily contesting the pre-court identification that took place the day after the incident.
So you're saying the record is clear that the only thing he identified was that the suspect was black and what he was wearing? And he didn't identify high cheekbones or facial hair prior, before he was shown the photograph?
According to Officer West's testimony, yes, that is correct.
Okay.
Now, to be fair, Officer West doesn't explicitly state that he didn't give that information, but when asked, what description did you give to the crime squad, he says, I told them it was a black male with a beanie and a T-shirt. Then for his in-court identification, and the court can look at the present tense that he uses, he says he has, present tense, a beard and high cheekbones.
Okay. Thank you.
Your Honors.
Thank you so much for both of you for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day.